Did you provide services at 5748 Plumdale Road?
Yes, sir, I did.
Is the estimate that you provided for that job on the screen right now? I'm having a hard time.
Yes, it is.
Plans Exhibit 1.
Mm-hmm.
And this one's already been admitted, but there's an amount that shows $67,525. Is that an accurate depiction of the services provided?
I don't think that has been admitted.
No, it hasn't.
Oh, okay.
This has not been admitted.
Okay. Then, so, Mr. Clement, this Exhibit 1, is that what you provided to the plaintiff with regard to services that you provided at that address?
Yes, sir.
And where did you provide these services?
Yes, I did. Except the wooden deck was subcontracted. That I actually paid a subcontractor to actually do by the name of Zach, but he basically worked for me. But all the other services, yes, we provided.
This is an accurate depiction of the work that was performed.
Yes, sir.
And this is a document that you commonly keep in the course of your business?
Yes, I do.
And it doesn't look as though it's been altered from what you provided?
Not at all. You can't.
We move to introduce Plaintiff's Exhibit 1.
Any objection?
Objection on the best evidence rule, Judge. This is not an invoice. This is a pre-job estimate. It doesn't establish any particular numbers or that any of this was actually paid. And plaintiff doesn't have anything showing it was paid. So
I have the actual invoice, and I have the actual payment history stuff. When Maurice asked me to send over the paperwork, he asked me for an estimate, not knowing what this was going for court. He asked me for an estimate. Can I bring up the paperwork of what I did, so on and so forth? And I shot him where I shot him. But I do have all the records on file because my system won't let me close out an estimate once approved. It won't let me close it out unless it's paid for. And I have an invoice, and I have the actual payment dates per invoice, per payments.
Your Honor,
so was this estimate paid?
Can I just jump in here for a second? Once again, we have a witness saying, I can get it, I could have gotten it. How about they should have gotten it, and today's the day? It's their trial, it's their case. All of this testimony.
Objections overruled. This Exhibit 1 is admitted.
Yes, this estimate was paid.
And who paid it?
Maurice. I'll call him Mo. Maurice, my lord, paid it.
Okay. Did you receive any payments from Marquise, Milord-Sims?
At this time, honestly, at that time of doing business, I never knew Marquise like that. I've heard about him. I'm a family friend, yes, but I've always heard about Marquise. I never seen him because he was never at the property or anything like that. I've heard that he said that I would call him. I don't even have a number or phone number for Marquise now or ever had, because it was never, me and his father are friends. So, I don't do me and the kids phone numbers type stuff. So
you haven't had any correspondence with Marquise, Milord-Sims, with regard to payment of your invoice?
No, not at all.
And you haven't had any correspondence with him with regard to any work that you performed?
No, sir.
You passed the witness, Your Honor.
Any cross?
Yes, Judge. Plaintiff's Exhibit 9, or actually Defendant's Exhibit 9.
Okay.
Mr. Clement, have you ever seen this document before? Can you blow it up, Ruth? It's a Home Depot receipt. You ever see that?
I've seen several Home Depot receipts.
Okay, but have you seen this one? Oops, something.
This receipt, I have not seen this receipt.
Okay, so can you look, and I know it's small, but there's a line item in here that says POD. Is that it? Job name, Milord.
Uh-huh.
Okay, so is that typically what you would tell Home Depot, that you have job names?
First of all, if I was to do this, this would be under my pro account number, which would be my actual phone number, which will actually show B&H contractors. So this is not a receipt from that was used through me, or I went to a store and did this.
Okay, so right below where we were just looking, it says customer recognition number 0315. What's that?
That is not 0315.
That's your membership level, right?
That is my what?
Are you a member? Because it says membership level.
Yes, I'm a member, but that's not my phone. That's not my number.
What is your number?
My number is 6648. It's my phone number.
Okay. And this was paid by a debit card. You know whose card that is?
No.
Okay, thank you. Mr. Clement, since you've never met Marquise, my client, the son, and never spoken to him.
Please. I never said I didn't meet him. I said I didn't meet him at this time. I've met Marquise later on because I was in a wedding and different things of that nature.
Hold on just a second. Wait, is that stuff? Let's pull that back up, Ruth. Exhibit 9. Okay, let's go to the second page. We're going to look at plaintiff's exhibit 9 again. I'm sorry, defendant's exhibit 9.
Mm-hmm.
You see that this is an invoice from Home Depot to you.
Mm-hmm.
And it has a number on it and an amount, $1,311.47.
Correct.
Okay, and it ends up balance due including taxes, just over $1,400. But the first page is the receipt. And you're saying you don't know who paid it?
No, I don't know who paid it. If you use at Home Depot, if you use a phone number, which everybody does, since I'm a contractor, everyone, you use my phone number, you can go in today and use my phone number and have my information on your receipt. You pay for it, and it'll have my information on there.
Okay, so who paid for this one?
I have no idea. I did not pay for it.
Who picked up the supplies and everything?
Who picked up the supplies? Who knows who picked up the supplies? Again, this stuff, the flooring, the Marquise picked it up, like he said. He went and paid for it, and he picked it up since I told him to go get it. That was his testimony.
Marquise, right? My client, Marquise.
Yeah, that's what he said, right?
Not the father, Marquise.
But I'm saying that's what your client said. I have no way of knowing who paid for this, sir.
So the invoice doesn't come to you?
This invoice this invoice here. So what I'm trying to understand, you have two different numbers. How you have a 15, you have a 0315, and then you have a 6648.
Yeah, I'm just trying to make this quick.
Are they the exact same? Because you got a different debit card on this one too. If you look at it, because it shows a different debit card number.
Hold on. It's the same exact amount, $1,311.47, right?
So what I'm asking is, you have a membership number of 0315, which is not my number, but then you have here 6648, which is my number.
Okay, so you were involved in these supplies and the purchase thereof.
I'm the contractor on the job. I have to be involved on it. But who paid for these things? Who used my information? I've only dealt with Maurice Milord on all transactions, all work there, because Marquise was never there.
Okay, but these do relate to work you did on the home and you don't know who paid it.
No, as long as you pay me for my labor, I don't care how you got it. Fell off the truck.
Well, sir, kind of the problem here, I think, is you're saying you don't know anything about this paperwork and who did what, but how did my client get it if he wasn't the one that paid it?
How did your client get it?
Yeah.
His father, like you said, his father must have gave. Look, I honestly don't know. I don't want to put things out there, but I never, through this process, I never met Marquise through this process.
You don't know who paid what to you.
I don't know material-wise. I don't know
Yes.
who pays for the materials.
And you
I
have
know
no knowledge.
I know who paid me for my labor and my work, but I don't know who paid for the materials.
I got you. I understand. So the person that paid you for your labor and work was the father, Maurice. That's your testimony?
Yes,
But
sir.
you don't know if his son was paying him so that you could pay you, right?
I don't know
Objection
who.
form.
Overruled.
Repeat the question.
You don't have any personal knowledge of my client, the son, reimbursing his father, your contact, for this money to pay you. You don't have any knowledge
No, I
of that.
have no. Why would I? That's not none of my business. I'm there to do a job. I'm not
Yes,
in
and how did Maurice pay you?
I need to
I
take a
have.
quick, guys, I need to take a quick break. I'm sorry.
Okay, Judge, sorry.
All right, go ahead. You can proceed.
Okay. So I think we ended up with, you don't know of any financial reimbursements or payback to your friend Maurice Milord about this house.
No, sir.
Okay. And you don't have any knowledge about any agreements between your friend Maurice Milord and his son Marquise, my client.
Objection form.
It's.
Overruled.
I knew this was to be a nursing home. I knew it was to be a nursing home. Story I got was, about his wife. Well, not wife. His kid's mom, and that he wanted to do something for them. That was
Okay.
basically it. It was basically like, hey, I'm trying to do this. Oh, this is a pretty good idea. All right, cool. I'm in on it. I'm help do whatever. We did the work. He paid me to do the work, and that was it.
Okay. But I'm going to try to keep this simple. You don't have any knowledge about any contracts or agreements between the father and the son involved in this case, do you?
At the time, again, I didn't know Marquise was really involved in anything there at the house. So it wouldn't be some kind of conversation from a contractor coming in and he's telling me, hey, this is what I'm trying to get done. Do you know somebody that can do this, this, and that? Have you ever heard of the guy that's doing sprinkler systems and things of that nature? There's nothing for me to really just say, yes, I knew they was in business together because Marquise was never there. I don't know him like that, but I knew Maurice, the father, was running a business because I did some work at another spot for him in Glen Heights.
Okay. I'm going to object to the responsiveness and try to keep this very simple. You don't have any knowledge, personal knowledge at all, of any agreements between the plaintiff and defendant, father, son in this case, do you?
No.
Thank you. No further questions, sir. Oh, one more. How much were you paid in total by the plaintiff, Maurice Milord, for this house job?
$67,300 something dollars, about $67,000.
And where do you get that amount from?
Where did I get the amount from, or where did he get the amount from to pay me?
No,
Paid
where
me
did
in
you
cash.
compute that amount? How did you come up with that final total?
I did the estimate on the job.
But an estimate's not a final bill, is it?
Objection,
If I
argument.
estimate a job, and I tell you that drywall is $4.25 a square foot, and we got 20 square feet, math don't lie. It's going to give you the exact number. So if I ask you and I tell you that I'm doing something for you at $60,000, I'm not going to overcharge you and say $63,000 because I spent 2 extra days doing something else.
Okay,
I don't do it. Go
okay.
ahead.
I just want to be clear now. This estimate, can you pull up Exhibit 1? This plaintiff's Exhibit 1, it's from your company, and it sounds like you're saying this estimate is actually a guaranteed amount. It's not going to
Yes,
change.
it is. It's not. It hasn't.
So the estimate is some kind of invoice?
I have the actual invoice that was converted. Again, Mr. Milord asked me for information based off of what we originally did. I sent him that. He did not tell me he needed a full whatever he asked me, and I didn't know we were doing trial or whatever. So I sent him what I sent him. But he paid me 20,000 plus in cash initially, and we did wire transfers after that. 2 wire transfers, 30% down payment, 30% progress, and 40% at the end.
Okay. Thank you very much, sir. No further questions. Pass the witness.
We can release this witness, Your Honor.
All right, is this witness here subject to a subpoena?
No.
All right, Mr. Clement, you are excused. Thank you so much for your testimony.
Thank you.
Call your next witness.
We call Leroy Willis.
Is Mr. Willis there?
Yes, I'm here.
All right, is that the one that says iPhone?
Yes, iPhone.
Yes, Your Honor.
Okay, sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes,
All right, you may proceed.
Please state your name for the record.
Leroy Willis.
And Mr. Willis, what do you do for a living?
I'm a fire alarm system installer.
Did you install a fire alarm system at 5748 Plumdale Road?
Yes, I did.
Who asked you to do that?
Maurice Milord.
And do you recall about when you performed that work?
Oh, I think we started around May of 2013, and then we ended up getting everything finished with fire inspection with the state and fire marshal. And I think my issue certificate around the August 15th of 2013, I believe it was.
And what was the reason you were installing it?
Well, because it was going to be like an assisted living facility, and the state requires to have a commercial fire alarm system.
So who hired you?
Maurice did. Maurice Milord.
Were you paid?
Yes,
Who paid you?
Maurice Milord.
You recall how much?
Ooh, not the exact amount, but it was between I think around a little over 6,000. But I don't have the exact amount because I don't have a contract.
Fair enough.
Yes.
Hold on, I need to share my screen. On your screen, are you seeing something that says plaintiff's exhibit 3?
No, it's I'm just seeing something spinning around saying Anthony Reed has started screening and sharing. That's all I see.
Let me give it one more time to populate. You see a document now?
No, it's still circling.
There's an email. You recall seeing an email on or about Sunday, May 5th to Maurice Milord concerning the fire alarm and camera installation?
May 5th.
Yes. It may be 6th.
You want to just show him the email?
I'm trying to. Yeah, I'm trying to get him to see plaintiff's exhibit 3, but apparently he said he can't see it.
Yeah, I'm not. It's not coming up. I'm still getting a circling, so it's not coming
Yeah,
through.
it's not coming up here either.
Can we screen share it for you, Mr. Reed?
Yes, if it's plaintiff's exhibit 3.
Okay, now I see a screenshot.
There we go. Thank you.
So plaintiff's exhibit 3, which has already been admitted, is this an email that you sent to, well, actually, is the email within the email shared on July 30th, the one referenced within that says forwarded message? Is Quality Alarm, what is that? Is that the name of your company?
Yes, Quality Alarm System. Yes.
Okay, and so you sent an email to Mr. Milord?
Right, I sure did.
Okay, and so there's equipment listed and labor and a camera system for a total of $2,334. Does that sound
Right.
accurate?
Yes, that's pretty much.
Did you install these things at the home at 5748 Plumdale?
I sure did. Yes.
And how were you paid for those services?
I was written. It was a check.
Okay, and who issued that check to you?
Mr. Milord.
Did you obtain that equipment yourself?
Yes.
Okay, and you performed the service?
Right.
Pass the witness, Your Honor.
Penny Cross?
Yes, Judge. Pretty briefly. Sir, you just testified that you think you charged a little over $6,000 before we looked at Exhibit 3, Plaintiff's Exhibit 3, right? You said over 6,000?
Yeah, because that's what normally most of them run.
Okay, but the actual number was far lower than that. In Exhibit 3, it says $2,334.
Yeah.
Okay, is that what you're actually paid?
Yes.
Do you have any records to show that with you today?
No, I don't.
So, Your Honor, I object on the basis of the best evidence rule. This is not evidence of him getting paid this amount, or who paid it.
Your Honor, we've already admitted 3, and I was utilizing his testimony to support the fact that this was the amount and he did get paid.
Okay, I take it back. I'm sorry, Judge. I'm going to ask you, oh, sorry, yes. Do you have any personal knowledge of any contracts or agreements of any kind between Maurice Milord and his son, Marquise Milord-Sims, the defendant in the case?
Objection relevant.
Overruled.
Okay, can you repeat that again, please?
I'll try to make it simpler. Do you have any personal knowledge about any contracts or agreements of any sort between the plaintiff and the defendant in this case?
No, I don't.
Did you ever talk to Marquise Milord?
No. No,
Do you know Sorry.
No, I don't know. I don't. No, I don't ever recall speaking to him.
Your Honor, I'd like to just, I guess, reiterate my objection on the best evidence rule. He has no records to substantiate this payment. This is just a bill with no evidence of payment.
Overruled.
Okay. No further questions.
We'll release this witness, Your Honor. He's not under subpoena.
Sir, you are excused. You may go forth.
Thank
Call
you.
your next witness.
We'd like to call Donnell Love. We called them.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Donnell Love,
Ms. Love, what do you do for a living?
realtor.
And are you familiar with the property located at 5748 Plumdale Road?
Yes, I am.
Why are you familiar with it?
I sold the property.
Okay. And when you went about finding this property, what was the basis for you finding this property?
Prior to, I was the realtor for Mr. Maurice Milord on his McKinney home. So the conversation was to sell his home in McKinney to be able to purchase the home on Plumdale.
Okay. Do you know the reason or the basis for the purchase on Plumdale?
The assisted living.
And why was this particular house chosen?
Found it on a foreclosure, cheaper property at the time.
And who contracted your services?
Mr. Milord, Maurice.
Do you know who paid the earnest money?
Who gave the earnest money to me or who purchased the earnest money?
Who purchased the earnest money?
Maurice Milord.
Do you have any understanding of the purchase price that was paid?
The full price of the home was $32,000.
And do you have any understanding about an arrangement between the parties for reimbursement of that amount?
Yes. Once the home sold in McKinney, Maurice was to get the money from the purchase of the home and purchase the Plumdale property from Marquise.
No further questions, Your Honor.
Ross?
Do you have anything in writing, ma'am, that shows Maurice Milord contracting for your services?
Yes.
Okay. What is that in writing?
IBS form.
Hold on just a second.
And the IBS form would be with Marquise because he was actually the purchaser.
If I may, can we pull up plaintiff 4 for me? Okay, got to blow that up. Is this the IBS form you're talking about?
No, that's the agent full report, just gives the property description on the property.
Did you bring the IBS form with you today or give it to counsel to use in this case?
No,
Why not?
I wasn't asked.
Are you familiar with Exhibit 4? Because that is a listing for this house. Have you seen this before?
Yes,
That's
that's the listing agent's property description.
Okay. You were not the listing agent.
No.
Right? Okay.
Buyer's agent.
Right. Okay. Now, pull up the earnest money to check. Sorry, Exhibit 10, I think. No, it's their exhibit. All right, pull up plaintiff's 8. Sorry, Judge. I'm getting there. Earnest money receipt. Okay, can you sort of blow that up and move it over to the left a little bit? Ma'am, Ms. Donnell, have you seen this before? This is Plaintiff's Exhibit 8. You ever seen this?
Yes.
Okay, and did you in fact receive this check in connection with the purchase of the home at Plumdale?
Yes, I did.
From whom did you get it?
Marquise.
But Marquise being the son, right?
Correct.
The defendant in this case.
Correct.
And he ultimately was the one who purchased the home and received the deed, right?
Correct.
Were you involved in that closing?
Yes, I was.
And this $3,200 was used?
For the earnest money, yes.
Was Maurice Milord there at the closing?
No,
Did he sign any contracts or any agreements relating to this closing?
no,
Are you aware of any agreements or contracts between Mark Milord, the son, and the father, Maurice Milord, about this property at all?
no contracts.
No
No
contracts?
documents.
Nothing in writing that you're aware of?
Not that I'm aware of, no.
In fact, you don't even have any knowledge of any agreement, written or unwritten. Isn't that right?
No,
You were not involved in their discussions if they happened?
I wasn't involved in their discussions outside of the purchase of the property.
Okay. Is there anything to your knowledge in writing saying this is how this transaction is going to work? Marquise going to buy this and then you're going to reimburse and get it somehow?
Not in writing.
Okay. Let me get out defendants one. Okay, we're going to look at the warranty deed that came out of this transaction. It's defendants exhibit 1. Have you ever seen this before?
I can't recall. It may have been in the closing documents.
Okay. Can you blow it up so we can see who's getting this property? Okay, so we blew it up. The very first paragraph shows Marquise Milord-Sims paying good and valuable consideration, doesn't it?
Yes,
And you are familiar with what that consideration was, aren't you?
correct.
Okay, you knew the purchase price and you already had the earnest money.
I'm sorry, can you repeat that?
Yes, you, in connection with this transaction, you had the earnest money and then you had the purchase price. You know the amounts of both, right?
Yes.
Okay. Can you scroll down? I just want to make sure if you've seen this before. I want to ask you, is this deed what was done to consummate the transaction you handled?
It had to be if it was in the closing documents, yes.
Okay. And that was April 13th, 2013, April 18th, 2013.
Correct.
Okay. No further questions, Paul.
Any redirect?
Just one. So just to clarify, you did say that you were aware of the purpose of the purchase of the home, correct?
Correct. Yes.
And then ultimately what was to happen thereafter, and I know you've testified to it, but just for purposes of restating, what was the expectation of what was happening with the house?
Assisted living home.
And as far as the purchase price, did you understand that there was some reimbursement mechanism or something as well?
Yes.
And what was that?
After the sale of the McKinney property for Mr. Maurice Milord, he would purchase the property on Plumdale and give Marquise that purchase price back.
No further questions, John.
Let me ask a question, Ms. Love. You're a realtor. Why didn't you facilitate the transfer of the deed if you knew this was going to be the deal?
Outside of that, I didn't know the time frame of when any work would be done, so I was done after the closing.
Okay, so you were not going to be involved at all in any of the transfer between the plaintiff and the defendant?
No, sir.
Okay. All right, anything else, guys?
I don't have any further questions, John.
Is this witness excused?
Yes, Your Honor.
Yes, Your Honor.
All right, ma'am. Ms. Love, you are excused. Thank you so much for your testimony. Call your next witness, Mr. Reed.
We don't have any further witnesses at this time, Your Honor.
Okay.
Your Honor, at this time, the defendant would like to move for directed verdict judgment. As a matter of law, we briefed these issues extensively yesterday. Both sides submitted a brief. So far, there has been zero evidence of any writings relating to any agreement about how this was going to work. There's been no real proof of any fraudulent intent. Frankly, the plaintiff's own testimony is that, he kind of jumped around a bit. We were in business together. He was in on everything.
So, Mr. Averill, this is a directed verdict. So the way I handle directed verdicts are that you need to go through cause of action by cause of action and tell me what you're moving for a directed verdict on and on what basis. So this isn't a chance for you to do a closing argument. So what is your directed verdict based on?
First, Your Honor, the only proper cause of action for a property dispute in the state of Texas is trespass to try title, and they have not pleaded trespass to try title. They don't have an existing property action in this case. There is no such thing as declaratory judgment for property, and there is no such thing as suit to quiet title, which are both of the things they are alleging property-wise. It's been very clear in Texas for the last 15 years at least. You cannot bring declaratory judgment actions just to try to get attorney's fees in a declaratory judgment. It is always and has to be trespass to try title. Statute itself says that. This is the method for determining rights and property. So they don't have a live cause of action that's cognizable in the state of Texas as to, their pleadings. So then they have misrepresentation and fraud claims. I didn't hear anything about fraud coming out of there. And, the fraudulent concealment idea, if we take Mr. Milord's story, the plaintiff's story, to be true, he sat there for 8 years after sending money over to my client, never asked for a deed. There's nothing in writing saying he's entitled to any kind of ownership instrument. And I find it absolutely fascinating that plaintiffs have produced 0 communications between father and son in writing. 0, not one, which strikes me. The only one that is in evidence is the email by which the father, the plaintiff here, forwarded the fire alarm cost to my client, which actually is evidence in favor of my client. My client was paying these bills and he paid that one.
Okay, Mr. Averill, I'm going to give you one last chance to do a directed verdict. This is a closing argument we're doing here.
Okay, well,
So Mr. Reed has certain causes of action.
yes.
So let's go through the causes of action one at a time. Mr. Reed, what's your first cause of action?
The cause of action is for a declaratory judgment.
And you're arguing that you cannot use that in the way that it's being used. That's what you're arguing, right?
Absolutely correct.
Mr. Reed, what's your response?
The response is that in a Dex action, it is appropriate to determine the property issue if it's based upon a breach of the oral contract. We believe that we've laid the foundation for the statute of fraud issue.
May I respond, Judge?
Response.
Yes, that's not the law. And the Texas Supreme Court has made very clear for a long time. Declaratory judgments only apply to boundary disputes insofar as property law is concerned. They do not and cannot be used to resolve property disputes and try to get attorney's fees. And there is no suit to quiet title in the state of Texas. It's trespass to try title. Been well established for many, many years. Can't do it.
Okay. What's your next base? And you're not arguing that there's any type of statute of limitations issues with the declaratory judgment.
Well, I think that if that is a proper cause of action, then both are in place, statute of frauds and statute of limitations, even if that were proper, for sake of argument.
Okay. Response?
Your Honor, our response is that we briefed those issues and we believe that we shored up both statute of limitations and statute of frauds in our pretrial brief.
But this issue right now is this cause of action. His Honor has already told us that's what we're going through right now. What you breached was in general limitations and fraud. But this cause of action doesn't exist in Texas. It's different than.
For all this reasons stated, including the statute of limitations, statute of fraud, I'm going to grant a directed verdict on the declaratory judgment claim. What's your second claim?
Fraudulent misrepresentation, Judge. I did not hear any promises and there's no agreement. So yes, statute of frauds definitely applies to this because there's no writing. So if he thought he was supposed to get a deed, Judge, I mean, he had a lot of time to say, hey, where's my deed?
Are you moving directed verdict on just statute of frauds or also statute of limitations?
As to all of them, statute of limitations and statute of frauds. There's no, it's called the statute of frauds for a reason. It applies to fraud. So yes, statute of frauds and limitations. All of this stuff happened over 8 years ago, and they only sued in this court a year ago with these claims. It's long since passed.
Mr. Reed, what fraudulent statements have occurred within the period of the statute of limitations? I guess that's what I'm trying to get. I don't remember hearing of any. I mean, I could see possibly there'd be a fraud claim that would have occurred back when the transaction occurred, but what fraudulent statement has occurred within the last 2 years?
The issue is, and even based upon the testimony, the allegations that the defendant has contributed to the improvements at the property, he's attempting to play both sides of the coin with regard to his knowledge of Renee's house as to whether or not a business actually operates there or not. His own testimony specified the basis for him purchasing the house was for it to be passive income and rental income residential property, but purportedly he's claiming, and we have testimony from the contractor that says he didn't pay for the alarm system, but he did have knowledge and is not denying he received an email.
But all this happened back in 2013, right?
Correct. But I'm saying
that's my issue is
okay.
What's happened. You guys didn't file until what, 2019? Is that right?
2020 in response to his forcible detainer action, yes.
Right. I mean, what fraudulent statements have happened within the period of the statute of limitations?
From the perspective of fraudulent concealment includes not just his positive statements, but his silence as well. So from our perspective, the fraudulent concealment is that he did not specify that he didn't have the intent to transfer the property back to the plaintiff. Purposely withheld that. I'm sorry.
Go ahead.
I'm saying he purposely withheld that information from the plaintiff, and the plaintiff never had any notice of that occurring until the forcible detainer action occurred, which was why I started with that's when it accrued. But thereafter, if the court were to rule otherwise, then he concealed that fact from my client through that period of time.
Mr. Averill, responding just to that last point.
Yeah, silence and showing fraudulent intent does not work. And again, I'll just say the father, the plaintiff here, never asked. There is no communication, not even a contract of writing, but no communications about this at all, this whole thing. So we can't make a fraudulent representation when we're not even being asked anything about it. He couldn't have because his father never asked. And limitations does apply, and they could have discovered all of this. And that kind of goes right into the discovery rule. It's not just didn't know, even if you believe the story, it is, could you have known with the exercise of reasonable diligence? Judge, this is not a fraudulent concealment case. The man knew, according to his own story, that he was entitled to a deed. And we disagree with that, but he knew back when that he was supposed to get a deed and never asked for it. And I think it's because he didn't want to pay the taxes, which my client paid. That's why he didn't want the deed. If it ever happened, we say that never happened. So there were no fraudulent misrepresentations.
I'm going to grant a directed verdict on this cause of action for all the grounds stated. What other cause of action do you have, Mr. Reed?
The next one's fraud.
I assume the same argument.
Yes, Your Honor.
Yes, Judge.
Going to grant directed verdict on that as well. Anything else? Any other causes of action?
Breach of contract.
Yeah, that one's even stronger. For directed, that especially for statute of frauds, but statute of frauds and directed verdict on statute of limitations as well.
Right.
What
and
else?
The last, well, there's two. Unjust enrichment.
Well, may I respond to that one quickly, Judge?
Yeah.
There was no proof of how much my client was supposedly enriched or how much he was enriched, the plaintiff. If anybody was unjustly enriched, it was the plaintiff. He's made money on this thing and lived there rent-free for 8 years. Doesn't need
Okay,
to.
so let me say this. I disagree with that argument. I do think that there could have been a valid claim for unjust enrichment here. I think that's probably the strongest claim actually here. But how do you respond to and I don't think statute of frauds would apply to that, So the only issue on unjust enrichment in my mind is the statute of limitations. Are you asserting statute of limitations on this claim as well?
Absolutely. This stuff happened a long time ago. And if he didn't get his deed and my client was getting enriched, he could have at any time even sent an email, hey, where's my deed, or anything. This is long since passed. It's about 4 years past. It's literally 8 years, and they had 4 more years after before they filed suit.
I would strongly disagree from the perspective of unjust enrichment. And once again, this is because of the accrual date of that cause of action. I don't believe that the accrual date would actually be in December when my client paid for the reimbursement. I believe that the accrual date is when the forcible detainer action was filed. And the reason being, what is the enrichment? Because the defendant's attorney's prior argument has been, what is my client getting? If the court were to rule right now that the defendant keeps the property, he's keeping the $3,200 that my client has shown that he took out of his own Chase account to pay for that earnest money check. He's keeping the $32,000 that my client paid him, which he's saying he doesn't know why his dad gave it to him, but clearly there was an understanding that he was going to be reimbursing him for the property. It just so happens to be the remaining amount of the purchase price. All of the improvements, and yes, Your Honor, my client has not produced an invoice, but he has produced the person that did the work, performed the work, stated that the estimate was an appropriate amount, and that he received that money from Mr. Milord via a two wire transfers and cash. So he has specified that $67,525 was paid by Mr. Milord.
When was the $67,000 paid?
Well, we didn't get an actual date of when it was paid, just that it was paid by
what year?
I would say 2013.
So,
I think that,
Mr. Averill, I think this is the closest call here is the unjust enrichment claim. There's a couple ways we can handle this. Do you have any witnesses at this point?
well, it was going to be my client, Judge, but the accrual date argument was already rejected by Your Honor to grant limitation or grant directed verdict on the earlier claims. There's no accrual date. The man knew back then what he was supposed to be getting, if you believe his story. So if he wasn't getting what he was supposed to be getting, then he should have communicated about it, and he waited far too long to do something about it. So the accrual date's already part of Your Honor's directed verdicts, I think.
And I would disagree, because the damages, you can't have a ripe claim without the damages for it. There is no unjust enrichment until the defendant attempts to dispossess my client without compensation. There is no argument for reimbursement if a deed is transferred. If he loses the property and he loses the money he put into the property, that's when the accrual date occurs.
Yes.
I don't see how he could possibly, you could easily argue ripeness if my client had attempted to file an unjust enrichment claim earlier.
Your Honor, there's another problem with that claim. Based on the evidence, you didn't have any evidence of the amount he claims my client was unjustly enriched for or what he was robbed of. Right? There's no testimony, evidence. They don't, on many of these witnesses, they don't have actual exhibits. There's nothing in writing. They don't have.
Mr. Averill, we're dealing with a directed verdict at this point.
Yes.
I believe there's sufficient evidence to get to the fact finder on the issue of unjust enrichment. The only issue I have on this one is in terms of getting to a fact finder on this, because that's what we're doing right now, is the issue of the statute of limitations argument. I think you may have a valid statute of limitations argument, but I'm not quite as confident about that as I am about the other claims. Clearly breach of contract, the statute of limitations is run, in my opinion, but I'm not as certain about unjust enrichment, and that's kind of where I am right now. And so there's a couple ways we could handle this. We could just finish the trial, and then you guys can brief the issue of unjust enrichment and the statute of limitations and how the accrual date works for that, or I'm open to suggestions on how you want to go forward, but I'm not sure a directed verdict is appropriate on the unjust enrichment claim. And so, but I wouldn't be opposed to getting some additional briefing on it. Does that make
I don't
sense?
have any opposition to briefing the issue, Your Honor.
Well, Your Honor, yes, as long as we get rid of the last one, fraud in a real estate transaction. Yeah, we're not there yet.
I'll grant summary judgment. I'm sorry, a directed verdict on that as well. It's to me that the only really possible claim that could survive is the unjust enrichment. And I think if that was filed on time, it's actually, I think, a fairly good claim.
But it wasn't. It wasn't filed on time.
That's what I'm struggling with, is was it filed on time, and what is the accrual date for that, and how do you deal with those issues?
I'm sorry to, just one more. They haven't proved how my client was unjustly enriched. He hasn't gotten anything from this house. He hasn't gotten any of the revenues. He's paid all the taxes. How is he unjustly?
Mr. Averill, I'm going to say it again, and I'm really trying to be kind here, is he owns this property. Somebody has put his father has put, I think at least there's evidence that his father has put $70,000 into this and paid him $32,000 for this home. That is sufficient evidence to me to get to a fact finder on the issue of unjust enrichment. That's the unjust enrichment. If you want to waive your claim for statute of limitations, continue to argue this, you can. The only thing that I think that would dismiss this claim at this point is the statute of limitations issue. So if you want to brief that, you can, or however you guys want to do it. But I'm just trying to be as transparent as possible of how I see this. But I do not disagree. I do not agree with you at all that there's no evidence of unjust enrichment in this case. I think there's ample evidence in this case of unjust enrichment. The question is, did statute of limitations run on that? And so you can keep arguing it, but I'm just trying to be transparent on what my views on it are.
Okay, well,
Your Honor, I'm sorry, go ahead.
I suppose, Judge, we have Mark Milord ready to testify, and maybe that will be evidence. But if we can just sort of put that in abeyance, Judge, I mean, can you submit an affidavit with the briefing on unjust enrichment so we don't have to have a whole new trial and just have that one issue?
Say that again.
Well, our witness is Mark Milord. We could put him on today and talk about things, but we're still at the directed verdict stage. I think that's what Your Honor is saying. And so the limitations argument has to be briefed. But I'm wondering, could he do an affidavit in connection with this, or do we have to reconvene if we can't just get it granted on the briefs?
Okay, so I'm kind of looking right now at, do you guys have your O'Connor's causes of action with you?
There may be one in my office.
Hold on.
So I'm looking at section 5C4, which is limitations on quantum merit or unjust enrichment. And what it says is when an action for quantum merit accrues depends on whether the work performed had a definite goal and stopping point, or whether the work was an ongoing arrangement with an indefinite stopping point. For ongoing work, the accrual date accrues when the services were performed.
Right. The only evidence we heard today was stuff that was done in 2013, Judge. That work was done. They were all separate jobs. They were done back then. It wasn't some continuing, keeping them on retainer and fixing property up. It was all done back then.
Yeah, that does seem to be the law on this. Is there, I didn't hear any evidence of anything that was done, any work that was done within the statute of limitations is 4 years. Is there any evidence of any type of work or payment made in the last 4 years or 4 years prior to the filing of the lawsuit?
Not that not that is presently a part of the exhibits or the testimony, no. But I would still make an argument with regard to the accrual date. I don't object to opposing counsel's offer of having his supporting affidavit along with briefing the issue.
Okay.
And I
Well,
would just say, I mean, we need to brief the issue. I would brief the issue as well and provide a supporting affidavit to substantiate why it would be appropriate.
yes, Judge, and I thank you for seeing that in the causes of action. I mean, that makes sense. It's just like lien rights and things for material, man. You have to file in a certain period of time in that circumstance after you do work. And those lien rights accrue when the work is done under certain time frames, 30 days, 90 days for different things. All of this work ended a long time ago.
I think the ongoing work argument, it would be if this was a contractor suing. My client continued to operate a business and he's being dispossessed of his livelihood, his business. There are people that live there. These are all being dispossessed. And that did not accrue until the forcible detainer action was filed. And as I said before, Your Honor, I don't have that case law in front of me right now. That's why I'm agreeing to brief the issue.
Okay. Mr. Averill, it's up to you. You can call your witness if you'd like, or we can go ahead and you can submit an affidavit. I mean, really the only thing, my gut is that probably the statute of limitations is run on the quantum merit as well, but I don't feel comfortable enough to grant a directed verdict without additional briefing on it. I guess what we could also do is you guys could brief this issue, and if I decide that I want to complete the trial, we can complete it on Tuesday morning if you guys want to do that.
I'd be okay with that, Judge. I'm available. I'm not going anywhere.
Mr. Reed, what's your schedule like Tuesday morning?
I don't have anything on the calendar Tuesday morning, Your Honor.
Okay, so just to make it clear what we're doing, both sides are going to brief the issue of what the statute of limitations is. And so this is just a brief, just want to make it 100% clear. This is just going to be a very short brief, 3 pages or less, on the issue of, and you can attach cases if you have any cases you think are favorable, on the issue of whether or not the statute of limitations has run on the quantum merit claim based on the evidence that's submitted. As I understand it, Mr. Reed, the plaintiff is rested, correct?
Yes, Your Honor.
So you can't go back and say, I would bring in this following evidence because you've rested. So based on the evidence submitted, what evidence is there that the statute of limitations essentially is not run, which I think it probably has, but I'm not 100% sure. So, and then if I determine that that I need additional argument or we need to finish the trial, your only witness is your client, right, Mr. Averill?
Yes, and myself, if attorney's fees were eligible, but at this point, yes, just my client would like to get it over with. So.
Okay. All righty. So try to get me that brief by Friday at noon. Email my court coordinator and e-file it and make sure it's indicated that that this is a brief in support of the or against the directed verdict motion on the issue of statute of limitations for the quantum merit. Mr. Averill, I don't want you, or Mr. Reed, I don't want you guys arguing anything else in this because I've already ruled on every other issue. If Mr. Reed, if you prevail on this, you're able to show the statute of limitations is not run, then I do think I'd probably rule in plaintiff's. I'll hear the defendant's argument, but I would probably rule in the plaintiff's favor on the issue of quantum merit. If you can somehow get past the statute of limitations issue.
Yes, Your Honor.
Judge, you said by Friday at noon. Did you mean Monday at noon?
So what's today? I'm sorry.
Today's Thursday.
Sorry, I'm thinking it's Tuesday. What would Monday at 2 be? Sorry, Monday. I'm sorry, my days are all off. Let's do Monday at 5, and then no matter what, we're going to reconvene at Tuesday, and I'll either I'll go ahead and either just make a ruling, or Mr. Averill, you're going to need to have your client there available to testify.
Yes, Judge.
Thank you, Your Honor.
What time Tuesday? 9 o'clock?
9 o'clock, and you'll need to request a link from Rhonda. So make sure you reach out to Rhonda and ask for the link for Tuesday.
I'll email her right now.
Okay.
Thank you very much, Judge. Closing
Thank
comments.
you, guys.